In this lecture, we will cover matters pertaining to appointment of the judges in Supreme Court and High Court. As we all know, this area has been greatly debated in various forums. Now, first of all, we need to understand what was the provision which was kept originally in the Constitution of India. In fact, the same provision continues to be there since the 99th Amendment regarding National Judicial Appointment Commission has been held to be a violative of the basic feature of the Constitution, and it has been struck down. Now, when the Constitution was being framed, there was debate in the Assembly and in the Constituent Assembly, and there was a great deal of emphasis on ensuring that we have first-rate judiciary and judiciary which is largely independent and insulated from the political and executive interference. And the Assembly greatly relied on the recommendations made in the Sapru committee's report, which had inter alia suggested regarding the method of appointment of judges in the Supreme Court, and more or less similar provision came into existence in our Constitution. Now, as far as the appointment of a judge of a Supreme Court is concerned, the Article 124 says that it is for the President who has to issue the appointment, and it has to be issued in terms of a warrant under his hand and seal, because it's a high constitutional post. And while appointing the judges in Supreme Court, as per this provision of the Constitution, as per Article 124, the President may consult the such judges of Supreme Court and High Court as deemed necessary. So the Constitution did not say that the President has to consult has to consult 4 judges, 2 judges, or how many judges. That is not mentioned. It left it to the executive or the President that such judges as deemed necessary of the Supreme Court and High Court who could be consulted. And it also says, the article also says that in case of appointment of judges other than Chief Justice of India, the consultation with Chief Justice is must. So effectively, if you read the intent of this article, it was that the consultation has to be with the Chief Justice of India and also with the judges of Supreme Court and High Court. And it was consultation. So it basically had put the executive and judiciary on almost an equal footing. But of course, the provision was such that the view of judiciary, because they have this expertise, experience in their own field, their view has to have a predominant acceptance, not mentioned in so many words. Now, as far as the appointment of judge of High Court is concerned, there is a more or less similar provision which says that the President shall consult Chief Justice of India, the Governor of the state, and Chief Justice of the High Court in case the appointment is of the judge other than Chief Justice of High Court. So for appointment of judge in High Court, it has to be Chief Justice of India, the Governor of the state, and Chief Justice of High Court. Governor here would of course mean governor not in the independent discretion. Governor would of course take the recommendation of the cabinet, that is the government. So this is broadly the provision which existed in the Constitution of India, and it worked fine. However, it all started in 1981. The issue of referring the matter to the Supreme Court started in 1981, where the then law minister issued letter to the chief ministers asking for their response regarding posting of the additional judges. You know that under Article 224 in the High Court, you can have additional judges. Don't confuse it with ad hoc. It is not ad hoc. Ad hoc word is used only for Supreme Court, not for High Court. It is additional judges, and they are appointed for a period of 2 years, and in some cases they are also confirmed and made the permanent judges. So in that letter of 1981, the law minister had asked the states that to take the consent of these additional judges who would be willing to go to some other high court. So this created a lot of reaction amongst the judicial fraternity, mainly for the reason that it is amounting to compromising the independence of the judiciary, because it's some kind of a favor you're trying to give to the additional judges and make them permanent judges, and also seek their consent for going this case. First judge's case. And in the first judge's case, primacy of executive in the appointment of the judges. It also said that no authority can have veto power, and it has to be a consultation, exchange of views, etc. So after the first judge's case, actually, well, we can say that it is not the primacy of the judiciary. So first judge's case, then came the second judge's case. That was in 1993. The second judge's case is brought out many important aspects. It in fact tilted the balance. If this is the balance was tilted towards judiciary and not the executive in terms of the appointment of judges. It also introduced the concept of collegiate concept, that the Chief Justice has to consult two other senior-most judges of the Supreme Court. It also said that no process for appointment of judges would start unless it is initiated by the Chief Justice of India. And if the recommendation sent by the Chief Justice of India uh, is not accepted regarding a particular person for appointment as judge of Supreme Court, if there are reservations, then the same have to be communicated to the Chief Justice of India. And if the Chief Justice of India reiterates its recommendation, then it would be proper for the government, for the president, to appoint that person as judge of Supreme Court, effectively giving the primacy to the judiciary. It also said that the president acts on the advice of the Council of Ministers, and as far as the appointment of judges is concerned, this process or this method of action by the president on the advice of Council of Ministers has to be read within the overall spirit of Article 124. This judgment also touched upon the tradition of appointing the senior most judge as the Chief Justice of India, and it said that this system should continue. Of course, the president will take the opinion of the judges of Supreme Court and High Court, but that is to ascertain whether the person who is getting appointed as Chief Justice of India is not at all suitable, and only in such cases that consultation for appointment of person to the Chief Justice should come into play, but ordinarily it is the senior most person to be appointed as Chief Justice of India. So these were the broad recommendations of the second judge's case. And the other aspect, yes, so now coming to the third judge's case. After second judge's case came the third judge's case. Third judge's case. And in fact, just before going to third judge's case, let me mention that Fali Nariman, who was the lead advocate representing the petitioners in the second judge's case, had later on made the observation that he won the case, but he would have preferred to lose it, because he made, in the context of the large scale, the wide criticism of the Collegium system, the opacity and lack of transparency in the system which was being seen in various quarters. There was criticism from people from within the judiciary. In that context, he said that, in fact, the judge, the senior most judge who was part of the judgment, also said that the intention was to have a system where there is an exchange of views between the judiciary and the executive, and there is no question of giving any kind of a primacy. Anyway, the judgment was interpreted in a manner that it gives primacy to the judiciary. Now, there was one instance after the second judge's case where the president did not agree to the recommendation for appointment of certain judges, and certain questions were framed, and the reference was made to the Supreme Court. That was in 1998. This third judge's case laid the final seal on the supremacy or the primacy of the judiciary in terms of appointment of the judges in the Supreme Court, and it reiterated the provisions of the second judge's case with some changes, like the Chief Justice of India had to consult four other senior most judges, that is the Collegium, and all the observations and the opinions have to be in writing. That was also their part of the second judge's case, also said that the exchange of opinion has to be in writing. This third judge's case also said the same thing. It only expanded the size of the collegium to four senior most judges of the Supreme Court. And it also said that the majority view will prevail, and it also went to the extent of saying that in case two judges do not agree to the particular person for being recommended for appointment to the post of the judge of Supreme Court, then such name should not be considered. So this was by and large the outcome of the second judge's case, which continued with the tradition of the primacy of judiciary in appointment of judges, which started with the second judge's case. Now this collegium system continued to attract criticism from various quarters, and there were attempts to have a national judicial appointment commission. In fact, in Britain, till 2005, it was the executive which was appointing the judges, and later on, after that, after reforms, a system similar to a judicial appointment commission was adopted. So we also tried, the parliament made an amendment in 124, and 124A also was inserted for paving the way for National Judicial Appointment Commission, which would comprise the Chief Justice of India, the two senior most judges, two distinguished jurists, two or one distinguished jurist, and the law minister. Now, this was the 99th amendment, and people went to Supreme Court, and Supreme Court struck it down. The constitutional bench of Supreme Court had struck it down primarily that it attacks independence of judiciary. It was also critical of having eminent persons in the Judicial Appointment Commission other than the judges of Supreme Court. And it said that since independence of judiciary is the basic feature of the Constitution, we know that basic feature, this doctrine was laid by Keshav Bharati case, Keshav Nanda Bharati case in 1974 or 73. I'm not sure about the year, somewhere in that year. This Keshav Nanda Bharati case was watershed in the judicial pronouncement, because it laid bare the concept of the basic feature of the Constitution. The Constitution itself did not mention anything as the basic feature, but it said that there are certain basic features in the Constitution, like parliamentary form of government, fundamental rights, democratic system, etc., independence of judiciary. These are the features which are the basic features of the Constitution, and no power of amendment under 368 can go to the extent of altering the basic structure of the Constitution. So using that doctrine of basic structure of the Constitution, Supreme Court in this case had struck down the 99th Amendment, and as a result, Article 124 has been restored, and we continue to have third judge's case and the collegium system. But there was mentioned by Supreme Court to improve the collegium system, to have more transparency, and memorandum of procedure was drafted by the union government as to how to approach the process of appointment. The idea was to bring in more transparency, and there were also the mention of concepts like the national security, etc., where on that ground the appointment can be denied if the recommendation comes from the Supreme Court, even if it comes from the Collegium, the Government of India. President can deny on that ground, which has been criticized by even the committees of the parliament, saying that under the wheel of the national security, the executive would gain primacy in some cases in appointment of the judges of Supreme Court. Now, these are broadly the provisions, and since it is related, recently some issue has come about the re, re, of referring back the matter regarding appointment of one judge of High Court as a judge of Supreme Court on the ground that the person doesn't have adequate seniority, and also in terms of the representation of that particular High Court in terms of the number of judges in the Supreme Court. In fact, the third judge's case had made a mention about that while recommending judge of High Court, the 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 seniority is not necessarily always to be the primary consideration. A person of outstanding merit can, even if he doesn't fall in the seniority, can be recommended by the Collegium for appointment as judge of the Supreme Court. And the reference was also made regarding that the representation, adequate representation of the judges of the various high courts has to be kept into consideration while elevating the judge of High Court as a judge of Supreme Court when that name is sent by the Collegium. So these are means this aspect or this area would always remain in the realm of suspicion by one agency or the other, or by one institution or the other. The executive would like to have primacy to some extent under for some reason or the other, and judiciary is overcautious, will always be sensitive to its independence, because independence of judiciary is a primary requisite for survival of democracy and it is also a basic feature of the constitution. So these are the broad features, broad areas regarding appointment of the judges in the Supreme Court and High Court. Thank you.